This program is intended for a print-impaired audience and is a production of the Georgia Radio Reading Service, GARS. Thank you for joining us for this month's edition of Capitol View. I'm your host, Mike Galifianakis. Capitol View is a monthly program to inform you of legislative activity, disability law, and policy that could impact your lives. This month, I am speaking with Professor Peter Blanck on disability law and policy, including the area of accessibility in information and communication technology. Professor Blanck is a university professor at Syracuse University, an academic rank only awarded to 8 prior individuals at the New York School. He is also chairman of the Burton Blatt Institute at Syracuse University. The Burton Blatt Institute works globally to advance the civic, economic, and social participation of people with disabilities. Professor Blanck, welcome to Capitol View.
Oh, thank you. It's really a pleasure to be with you.
Professor Blanck, I wanted to start by asking you to share with our audience the story of Burton Blatt and the founding of the Burton Blatt Institute.
The story of Burton Blatt and my story goes back to before the Americans with Disabilities Act was passed in 1990. I'm kind of an odd bird. I'm a PhD researcher in psychology and also a lawyer. For a number of professional and personal reasons, like many of us, gravitated to this new area of disability law soon after the Americans with Disabilities Act was passed in 1990. I had been fortunate to conduct some very early studies on the nature of workplace accommodations, the nature of life in institutions versus community for people with disabilities, the nature of web accessibility, which was still in its infancy at the time. Actually, Tim Berners-Lee, the inventor of the World Wide Web, was writing the first reports in 1990 at the same time George Bush was signing the ADA into law.
Right, wow.
As a result of this research, I ended up in Iowa, working at the University of Iowa as a professor of law and medicine and other areas, and had the great fortune to get to know and work early on with Senator Tom Harkin, of course, who was a great Iowan senator who was one of the drafters of the Americans with Disabilities Act, and began working to understand the rights of individuals with disabilities under this law. Very quickly, of course, there was new litigation that was filed, and I began to be asked to explain some of the research I was doing so that it would help vindicate people's rights. I'll never forget, I got a call soon after the ADA was passed from then Commissioner of the Equal Employment Opportunity Commission, a guy named Paul Miller, who was a great disability leader. He had worked in the Clinton office. There was a case in Madison, Wisconsin. It was the first of its kind that was being brought under the ADA. It involved a great man who I have kept in touch with named Don Perkle, and he had worked at this pizza chain called Chuck E. Cheese. It's a pizza parlor with a big mouse, games, ball pits, and all sorts of things that kids love. An otherwise great place to go. And Don Perkle, who is nonverbal and also has intellectual disabilities, at the time it was referred to as mental retardation, was hired by Chuck E. Cheese. He was doing a great job. He was preparing pizzas, and he was working in some janitorial modes, and the staff loved him. Unfortunately, sometimes corporations we see under the ADA get it wrong. It doesn't necessarily mean they're totally bad actors, but a senior representative from the company came up to this little college town, Madison, Wisconsin, saw Don Perkle working at the Chuck E. Cheese and said, "Fire that guy. Basically, I don't like the way he looks." There was nothing, of course, at all wrong with Don or his work ethic or his work. Those attitudes were exactly the kind of attitudes that the ADA was meant to deal with. To their great credit, a sign of humanity that keeps us going once in a while, the local staff at the Chuck E. Cheese said, "If you fire Don, we're all going to quit and protest." Unfortunately, they proceeded to fire Don. They all quit and protest, and there was a trial under the Americans with Disabilities Act, one of the first of its kind, involving a person with intellectual disabilities and Don's right to work. After a multi-day trial, I had testified as an expert based on my research about the importance of work and accommodations and qualifications of individuals with disabilities. The jury found for Don $80,000 in back pay and other damages. And it was a great victory, the first of its kind in as everybody was kind of packing up, the jury foreperson asked the judge a question, and that was, so that this never happens again in our town, can we award Don an additional $13 million in punitive damages to send a message that this is wrong? The judge upheld it. There are caps on damages under the ADA, but I believe today it's still among the largest judgments of its kind. Interestingly, as a lawyer myself, lawyers are paid to be creative, sometimes good, sometimes less good. The lawyers for the defense filed a motion. They got a psychiatrist saying that there's no way that Don, as a person with an intellectual disability, could enjoy the fruits of $13 million. And the motion from the side that I was working with came back and said basically that Don would enjoy every penny of that $13 million, right. And the judgment was upheld. That was my introduction to this really evolving and new area and the building of an institute to study the ADA in action at the University of Iowa. It was called the Law, Health Policy, and Disability Center. Loving Iowa City and raising 4 kids there, kind of minding my own business and doing research, Syracuse University came a-knocking. Syracuse University has a long, really exemplary tradition in the area of disability and disability rights, perhaps among one of the best in the country. Of course, I was aware of Syracuse University, and they had a new chancellor at the time, a woman named Nancy Cantor, who went on to other presidencies, had been the president of the University of Illinois, very accomplished visionary, and she began recruiting me to build a similar institute at Syracuse University. Now, Nancy Cantor, like many of us, her life was in many ways defined not by her prominence in the field and being a president of a university and really a global scholar, but by her relationship with her son Archie, who had autism. And she understood what it meant to infuse disability and concepts of inclusion and integration into all aspects of daily life. They graciously, as the saying goes, made me an offer I couldn't refuse, and it turned out that at Syracuse University, a beloved dean who had passed away, unfortunately, quite young, a dean of the School of Education, was named Burton Blatt. And Burton Blatt, in the 1970s, with his colleague, Mr. Kaplan, basically got into the old institutions, the Willowbrook, Pennhurst, remember the deinstitutionalization movement?
Right.
But he got into those institutions before it hit the press, and they had a hidden camera on their belt, and they did this photographic expose called Christmas in Purgatory. It was really a portrait of the hellish life of individuals living in those institutions. And that really lit the fires of reform and was one of the earliest efforts to focus on the horrific conditions facing people with disabilities in the 1970s. Fast forward to Nancy Cantor and myself, the family of Burton Blatt, very gracious, prominent family, decided that in addition to me coming to Syracuse, they'd like to honor his memory by endowing this new institute called the Burton Blatt Institute. They wanted it to be, as it is, cross-disciplinary, across the life course, and work with economists, lawyers, physicians, political scientists, and so forth. And so we established at Syracuse University as a university institute, which meant in reporting to the chancellor, we tried to work with all the colleges around the campus to focus basically on the social and financial inclusion of people with disabilities, broadly speaking, in America. This was before the UN Convention on the Rights of Persons with Disabilities.
Okay.
As a result of that, we have been very blessed to grow quite significantly with scores of staff in Syracuse, in New York City now, in Atlanta, Lexington, Kentucky, Washington, D.C., soon to be in California. And we are a niche, credible think tank that does leading-edge research and outreach in the area that is driven by people with disabilities and people who have experience in their families or elsewhere with disabilities to try to make a little dent in the universe. That's my long introduction, Mike. I hope not too long.
No,
to your simple question about Burton Blatt.
No, and thank you so much. It's such a great perspective and such a great overview, and really appreciate it is about individuals making a difference all along the way. You mentioned that Burton Blatt Institute is a cross-discipline entity. Can you give the audience a sample of some of the current programs or initiatives that the Institute is involved with?
We take our cue by leading-edge issues, we hope, in the disability and broadly general equality civil rights area. I'll give you an example. Years ago, after the ADA was passed, probably the late 1990s, the Internet was just coming alive in a real sense, way before e-commerce and social media and Facebook and all of that. Because of my writings on inclusion and accessibility, I was very fortunate to be co-counsel with some amazing lawyers who were leading at Disability Rights Advocates. Disability Rights Advocates is a leading disability rights law firm based out of Oakland. We were representing the National Federation of the Blind against Target Doors. You know Target, of course.
Yes.
And at the time, Target's website was basically not accessible to people who were blind. There were alt tags that didn't have text, and there was different navigational techniques. Litigation ensued, unfortunately. Today, I believe that Target, like many corporations, probably are exemplar in this regard, but at that time, it was a very new thing. As a result of that litigation in California, we created some of the first really good law that, under certain circumstances, the Americans with Disabilities Act is broad enough to cover people who are blind so that they have website accessibility, which at the time was not such a simple question.
I think that's an interesting aspect of law and policy that the ADA was enacted in 1990, and I think you said parallel to that in the 90s, the World Wide Web was being developed, but it seems like in the early 90s, the ADA was not able to specifically address how you make websites accessible or how do you ensure technology applications are going to be accessible to people with disabilities. So could you talk a little bit about how law seems to almost have to play catch up sometime with what's going on?
Sometimes technology leads, sometimes civil rights leads. So to complete that story, as a result of that litigation, remember the ADA doesn't talk about specific website accessibility, as you say. It talks about full and equal access. How that's defined, of course, can be the big question. But as a result of that litigation and the work we did in that area, the Burton Blatt Institute and the Iowa Institute were very fortunate to receive large grants. For example, one called IT Works, about how we make and what sort of strategies can be used to make the workplace accessible for people with disabilities. We're still playing that out a little bit today. The ADA gets a little bit of a bad rap, in my view, because there are some litigators out there, and every profession has people who kind of push it to the limit. Litigators who are doing scores and scores of litigation, almost en masse, against banks and corporations and others because their websites are not accessible. Now, don't get me wrong. If you've had 30 years to follow the law and you haven't done it, that's a big problem.
Yes.
But the problem is that the business community has a backlash to that, which ends up in legislatures or Congress, and all of a sudden there are calls for new laws about limiting the scope of the ADA. The bigger issue is that much of the Institute work derives from real-world issues. If I may, I can give you another example.
Please go ahead.
7 or 8 years ago, I got a call from an amazing lawyer named Jonathan Martinez, who had a case in a little courtroom in Hampton Roads, Virginia, representing a woman named Jenny Hatch. Jenny is a woman with Down syndrome, intellectual disabilities. She's an amazing woman, independent of that. She had her own job. She was working in the community. She lived where she wanted with friends. Unfortunately, due to a variety of circumstances, and this is not parents versus children and so forth, Jenny was about 29 at the time, so she's an adult woman. Her parents decided that they would want her to be under their complete guardianship. That would mean for Jenny that she wouldn't get to choose where she lived. She wouldn't get to have an iPhone and text with her friends. She wouldn't get to volunteer and work where she wants, and basically took away control from her for her life in those areas which she had shown that she can do just fine. So out of that little courtroom, I went down there and testified about the importance of self-determination and independence and the principles of the Americans with Disabilities Act. And for the first time in American history, kind of like Chuck E. Cheese, a court ruled that an individual like Jenny should have the right, or at least the chance, to be self-determined. And instead of guardianship, she should be allowed allowed this emerging concept called supported decision-making, which is essentially something we do every day, all of us. If I take my car into the auto mechanic, I rely on that mechanic or banker or anybody else to help me make those sorts of decisions. The idea is that 99% of the cases, guardianship historically has been overly restrictive. We know this as an empirical matter, and there's a lot of room for people to have more say in their lives. We won that case. It got a lot of press. Jenny was in People magazine and the Washington Post, so forth, and all the advocacy groups were very supportive of it. What happened then, and this comes back to why I hope the Institute can play a role in helping shape policy and research and so forth, we were funded by the Department of Health and Human Services and other organizations at the federal level to examine what this concept of supported decision-making was with our terrific partners in Washington, D.C. One's called Quality Trust, taking the lead on this. We established a national resource center for parents and individuals and organizations to better understand why the principles in the ADA of self-determination were so important. Today, we are looking at those principles both in other countries with other types of disabilities, for example, mental health disabilities, youth in transition. I go on a bit too long, but I want to illustrate to you our passion for trying to take leading-edge issues, and there are 3 or 4 other issues I can tell you about. I'm not sure we'll have time. Financial literacy and other areas in which we've tried to do the same thing.
I would love to learn more about supported decision-making. It's probably an evolving concept, and it's probably individualized based on a particular individual and what his or her needs are, but is that a legal concept now, or is that still developing?
This is a very good question. It's evolving.
Okay.
In the United States, historically, the state, each of the 50 states, were responsible for having laws about guardianship. And those laws typically ended up resulting in people having plenary guardianship. In other words, once you were under guardianship, whether you were an older adult or an individual with a cognitive disability, all of people's decisions were made by others. This new concept of supported decision-making was kind of a partial approach. We do it all the time, for example, with advanced directives or with powers of attorney.
Right.
It's just a different paradigm or way of thinking that has now been recognized in law and in state statute as an alternative to guardianship. For example, I don't know Georgia, but Virginia, Delaware, and a few other states have changed their guardianship laws so that the first priority to try to support the individual to make their own decisions before you take away their power to make their decisions.
Right. That's part of that evolving focus on what's best for the individual, how to assert that person's independent living rights.
Exactly. And we hope that what we do here at the Burton Blatt Institute is helpful in policy change, in law change, in systems change, and, of course, useful when people try to vindicate their right in a legal setting as well. And that's probably been one of the most satisfying things about what we try to do as a team. And this goes way back to our early work on deinstitutionalization when my colleagues and I, for example, did a very large study tracking thousands of people as they moved from institutional settings to community-based living settings after the Americans with Disabilities Act was passed.
If you're just joining us, you're listening to Capitol View and Professor Peter Blanck, University Professor at Syracuse University, who is discussing disability law and policy. Professor Blanck, you had just mentioned a few minutes ago that among all the many things that you're working on and studying, matters of economic literacy and self-sufficiency for people with disabilities?
Yes, very important area, of course. Been the great economic divides we're facing as a country today.
Could you share some of your work in that area?
I'd be delighted. It's a very good question, Mike. I have really the privilege of working with an amazing team in Washington, D.C. and elsewhere. One of our leaders on our research team is a guy named Michael Morris. Michael Morris has been in Washington, D.C. in our Washington office for many, many years. He has focused a large part of his career on financial empowerment for persons with disabilities. Most people with disabilities, as you know, Mike, live in poverty and don't have great career trajectory and great ways for saving money and becoming economically independent. So Michael was instrumental, as of course were many others, in helping to pass, President Obama signed into law in 2014, the ABLE Act, Achieving a Better Life Experience, which could be among the most important laws passed for people with disabilities since the ADA. In a nutshell, and I should say on our website, all of our materials are free. We have articles available. You can download them on all the topics I'm talking about at bbi.syr.edu.
Okay.
Why is the ABLE Act important? Basically what it is the states will set up savings account for individuals with disabilities who qualify, and they can save up to $100,000 tax-free. You can put money into these accounts, or your friends or family, and there's no taxes charged, and you can use all those funds for anything related to your disability broadly defined. That's really good. In addition to that, the person with the disability is the owner of the account.
Okay.
Again, empowerment. Nobody else owns it. The next most important thing of this trifecta is that historically, many people with disabilities have been dissuaded from working or from saving money for fear of this so-called income cliff.
Right.
That is, if you have a certain amount of money in your bank account or earnings, you lose your government health insurance benefits, typically through Medicaid or SSI.
That's a pervasive problem.
The brilliance, in my mind, of the ABLE Act is that this money that you're saving tax-free does not count against your income assessment for purposes of your governmental benefit. In other words, because you're doing a good job of saving, you're not going to be penalized and lose your government benefits. The idea being that this is a terrific incentive to pull people out of poverty, to provide them a venue for savings, and still keep the safety net of Social Security. So that's why I say I'd be interested in your reaction, Mike. It's an extremely important law. We worked on that, and as a result, Burton Blatt Institute, with its partner, the National Disability Institute, received some of the first grants to study the ABLE Act in action through randomized controlled trials, which is a fancy scientific medical term, trying to understand causality. Basically, we're going to have people assigned to different types of accounts and see how their quality of life is, their savings, their employment, and so forth. I just finished that story by, again, trying to convey to you how we have taken what we hope are leading-edge issues really affecting people with disabilities and turned that into a research program that furthers the effort.
Well, I think you answered part of my next question with regard to the ABLE Act and the data that you're going to be acquiring to make a determination of how successful it was. But whether we're talking about financial empowerment, supportive decision-making, or any of these other critically important areas Burton Blatt is working on, what are the critical factors that you believe are necessary for successful advocacy on that systems change level? If you can, share critical factors for successful advocacy on an individual level as well.
On the systems level, increasingly today, as we know, content is king. Good data and good information that is credible in an era in which we often hear, unfortunately, from many people in prominent positions that nothing in the news can be trusted or nothing in science can be trusted. My hope is that this is a period which we will eventually transcend and will moderate. But at the systems level, the legislators and the judges and the attorneys, in a small way like I have tried to do in my work, need hard, good information. That's how you can make policy change. The National Resource Center for Supported Decision-Making helps form people, provide resources, provides 24-hour technical assistance on these issues. At the individual level, it's a little more complicated because individual litigation, as you know, or your listeners know if they've ever been involved in it, there's so much emotion involved. There's so much unique circumstance. There's so much dug-in heels. And I would say that awareness of individual rights perhaps is one benefit of what we're trying to do.
Okay.
The people who go to trial under the ADA and with the Equal Employment Opportunity Commission, we have to believe are such a small tip of the top of the iceberg, people who rightly so choose not to go back to work, may choose not to go to that restaurant again, may choose to stay on governmental benefits. And this is a terrific loss, both economically, socially, and culturally to our country. One of my best friends who uses a wheelchair will always say to me, if I can't get into this restaurant is not just losing my meal ticket, they're losing the 5 friends and family members that I'm bringing with me.
Right.
And it's so true in so many areas, and I do believe that there are many good corporate and individual actors out there that get it, and I do believe also that many of the fears that companies will go out of business, that people with disabilities are not as qualified, whatever you hear, they just haven't proven true in empirical fact, and those are the sorts of studies we like to do.
In the few minutes we have left, I had a couple other specific questions. One, going back to the Institute being at Syracuse University and Syracuse being so supportive of disability studies generally, can you give the audience a sense of the type courses or programs that the university offers on disability-related matters or studies?
Syracuse University, to my knowledge, was the first disability studies program in the United States. It has the first disability cultural center in the United States, and there's a whole array of courses relating from economics to health, social work that look at those traditional concepts, not just from a disability perspective, but what's, of course, called from an intersectional perspective, that is, from the experience of race, gender, age. We all know that the experience of one individual from a certain culture who uses a wheelchair can be very different from a similar individual in a different culture or race or age. There's a very cross-disciplinary listing of courses, and we look at a whole range of things from portrayal of individuals with disabilities in film and the media to the economics of health and environment affecting people with disabilities, and it's been a very successful program. Now, of course, there are many fine universities that have disability studies programs. My one surprise, if I may, is that the top universities in the country, for some reason, don't seem to have gotten on the interest wagon in the area of disability studies. I don't know the reason for that, but I think there's a lot of room for many fine universities. Certainly, there are many fine universities in the Atlanta area that we work with that are engaged in this topic, including, I would say, by the way, some of our great partners at historically black and colleges who we're delighted to work with in the Atlanta area, such as Morehouse Spelman.
I'm glad to hear that universities in Atlanta are participating as well. The last question I had, going back to our discussion of accessible websites and the work you've done there, could you give us an outline or overview of what you think best practices are for developing accessible information and communication technology for individuals who are blind or have visual or print-related impairments?
Well, we're at such an exciting edge where we're beginning to see not just the concept of accessibility that is often individually tailored, but a move toward more universally designed strategies. That is, one size fits all, and as my colleagues say, one size fits one. For example, a colleague of mine named Greg Vanderhyde, central to an international organization called Raising the Floor. I happen to be president of the U.S. chapter of Raising the Floor. One of the main products of Raising the Floor, it's a nonprofit, it's been funded millions and millions of dollars by the United States and other governments, is to create tools and systems in the cloud, not on a particular device, so that you could pick up any device anywhere, your handheld, your laptop, phone, whatever, and it auto-personalized to your preferences, which have been pre-programmed in the cloud. Big font, beach, contrast, whatever. And I think increasingly we'll see this personalization of devices, which will do away with some of the early battles we had. Why? It will, number one, make sense for everybody. For example, if there's situational disability, noise or light or whatever. And number two, it'll bring more and more users into the fold. Many people before me have said dollars are as green as anybody else's. That's 1 billion people in the world, arguably, who report disabilities, and that economic force will not be overlooked as a result of that. So the move will be toward universal design, and then, of course, linking that to smart home, smart workplace, sensors. And the book that I wrote in this area is called Equality, and it's about some of the legal issues we have to think about as we move in this direction. For example, privacy, security, individualized approaches, and so forth, to make sure that this really benefits the most people possible. There's a lot of work to do, yes.
Professor Blanck, thank you so much for being part of our program, and really appreciate all the work that you do with the Burton Blatt Institute.
Thank you, Mike. It really has been a great honor to work with you and to know you and the great work you have done in Atlanta as well, and I hope we'll speak again in the future.
We will, and we look forward to it. You've been listening to Capitol View, an original program of the Georgia Radio Reading Service, GARS. This is Mike Galifianakis. Thank you for listening to GARS.